Any mention?
May I please, Lordship, I beg to mention item number 44, Lordship.
44.
Yes, Lordship.
List.
Your Worship, I'm appearing for the respondent, so responding, Your Worship.
Yes.
No objection, Your Worship.
Please don't make a... Prayer was a petitioner, not object to be the respondent. List of weeks. Yes.
Much obliged.
Supplementary cause list, item number 1.
My Lord, this matter pertains to pension of the ex-MDCs of the District Council. Now, my Lord, before I start, my Lord, I may just point out that this is not a service matter, my Lord. So I don't know, as per the roster, I don't know, my Lord.
This is not a service matter.
Not a service matter, my Lord.
Well, it is submitted by the Lord of Council, by the petitioners. Dispute involved in the writ petition. The grievance raised in the writ petition is does not come, is not related, is not a service matter
Not a service matter.
in view of the submission. This is matter before the appropriate court.
Deeply.
Daily list, item number 1.
Malot, in this matter, I would pray for some time. I have received one more RTI, Malot, in this regard. One more RTI was furnished to me yesterday, Malot. Malot, what had happened is that in a similar situated case, which along with the entire batch of writ petitioner, 2 employees, Malot, have been retained back by the respondent, Malot. Without, they have not approached this honorable court, Malot, just by virtue of a representation. They were put back to the casual post. Now they are back in regular post, my lord.
Now, just furnish us a copy of the service rule first.
My lord.
Please give it that. See, we would go, probably we have to go deeper in this matter.
Your lordship.
Deeper in the matter in the sense we'll definitely try to find out how many employees, those who are retained,
Your lordship.
have been taken into service on the basis of regular selection.
Your lordship.
Now that is what is relevant for
My lord. So I will provide, my lord, I will...
but then what your information, the recent information?
Well,
article
my recent
information,
information
what
as per
relevance
the
it has?
relevance, my lord. My relevance, my
Whether
lord.
it has any relevancy.
Relevancy is, my lord, same situation, my lord. Same situation. Whoever we are before your lordship, just because of the stay order, they have been retained back to the regular post, my lord.
So there is a discriminatory.
My lord. My lord. 2 of them has just filed a representation before the respondent. They have retained back. They have retained them back to the regular post, my lord. So if that is the case, my lord, if they can be retained, my lord, whatever difficulties the respondent is showing, or whatever they are talking about the rules regarding the appointment, my lord, that becomes diluted, my lord, in that case, my lord. And the other aspect, my lord, that clearly shows the aspect of discrimination, my lord.
So those RTA information will have bearing in all the cases, all these.
Absolutely, my lord. I've just received it yesterday evening, my lord. So I may be allowed
My
to.
contention is that, as your lordship has pointed out, whether there's any relevancy. Now, the petitioners have to stand on their own legs. They cannot say that because somebody has been retained, so my case also should be.
No, that is not that. You see,
The main-
if there is allegation of discrimination, definitely they will have to bring it on record, because they have to show how they are discriminated. Now, any fact which is relevant, because if you see the recent trend in the service law, there are a few decisions even by the apex court also. The proposition of Uma Devi, which is mostly relied on while adjudicating matter in relation to ad hoc employees, right of real knowledge,
Yes,
daily wages, casual hours. Now there are many decisions. It says that it doesn't give any right to the employer also to, you see, take into service any person and throw them out at their home services.
That is true. That is true.
Even if you see, maybe day before yesterday, when judgment came by a court, it is with regard to regularization.
Yes.
And Supreme Court says that authority cannot, regularize on pick and choose basis.
No, my lord, in
Now,
in these two cases, those can be distinguished. Why?
Definitely.
Why I'm saying that is, my lord, firstly, these are not sanctioned posts. They've been appointed to non-sanctioned posts. And secondly, it's against the service rules. Now, my lord, if your lordship goes into...
No, that is what is service rule. That is the crux of words.
Yes.
Now, if you say that you have a service rule,
Yes.
just tell us whether it has been given effect or not, and or how many instances it has been followed. Now, that is what we will call for. Probably we will direct you to file an affidavit. We would like to see if there is only a service rule and if it is only remains in book and it has never been acted upon. How can you oust others saying that their appointment is not in accordance with the rules? Then in such a case, you discharge all your employees.
We are willing to do that, in fact, my lord. I said...
You should do it, then why
Yes.
should that you take performance?
Yes.
Why you have written some and then why you have victimizing some?
My lord, as I said, there are two aspects to this matter. One is sanction post and one is recruitment. Now, in the petitioner's case, neither are the posts sanctioned, neither was there any recruitment.
Now we will see what is sanction post and what is not sanction post. That also needs to be gone into. Now, how many posts the sanctions posts were when the service rule came into being? When the service rule came into operation, how many sanction posts were there?
My God, sanction post is from day to day, year to year. Whenever it's required.
Exactly.
Yes,
That is
yes.
what. So now,
We cannot go back to 1951, my lord.
which way you accommodate people in the sanction post and which way you accommodate people in the non-sanction post?
But I had submitted, frankly, on the earlier occasion also,
We know.
saying...
We know. You
Yes.
see, Mr. Dingdo, today you are there. If some factual assertion comes from you, we need it to come by way of an affidavit. Because you may be counsel today, tomorrow you may not be there.
In fact, my lord,
So
it
we
has
would not
come...
like to decide a matter simply on the basis of your...
My lord, it has come by way of an affidavit by the petitioners themselves. They have...
That is, no, it has to come from you. See, the petitioner's affidavit is something that is mere assertion, and if it comes by your affidavit, then that will become an admission.
So, your lordship is desirous that I file an affidavit, I will do so within 2 days.
Just these are how many? Just earlier you had given us a chart.
Yes, yes.
See, the problem is that we have to pass separate orders in all those things. But then we will call for affidavit in all the cases.
My lord has got the chart.
Yes, we got the chart. You have a
Next page also. Next page also.
Yes, with the hand also.
In fact, there's one more case which have been filed recently.
That is not there in the chart.
It is not there. That is 364 of 2020.
Their affidavit is exchanged.
No.
In that one,
New
yes.
case.
No.
No.
It hasn't been.
Pardon.
Yes, we have a copy. Well, that is the one, isn't it? It's the same one.
Same one.
Behind we have
That
also
is
added,
it.
no. Behind also we have added the new case. Behind.
Okay, by hand.
Yes.
Enforcement constable. Now, how many cases concerning enforcement constable? 1, 2.
Enforcement.
This is a problem. You see, we have to do.
Number 5, number 4, my lord. Number 4 to number
11.
13.
Number 3 also is enforcement constable.
Yes.
Then 5, 6, 7, 8, 9, 10, 11, 12, 13, 14.
11 altogether, my lord.
This is revocation
12
of
altogether.
authorization. This is revocation of authorization. So far as this informant constable is concerned,
Yes.
there is no case of termination. It is only revocation of regularization. For all.
Reversal. Reversal.
Yes.
Reversal.
Is it? Yes. Now, then peon.
Peon are mixed, my lord. Some has been revoked,
And some have been
some have been
discontinued.
discontinued.
Can you prepare a chart?
My lord, I'll do that. What I'll do, my lord, I'll prepare a chart of as per the
What
post
would
wise.
have been convenient is that if you could pass common order in
Well,
all these things.
So I'll prepare a chart of post wise, my lord, along with the detail of
Common
the.
order can be passed in revocation, my lord, and then discontinuance would be again separate.
No, but then the issue is same.
Issue is same.
Issue is same. Issue is more or less same.
Yes.
Your basically the passing of the impugn order is only basis of one thing. You said that their appointment or regularization was not in accordance with the rules.
Not according to the rules, yes.
We do not know whether we can club it together. You can pass one order in all cases asking you to file an affidavit. Can be a common order. But then if you pass once common order, subsequently you can separate it. This thing the computer will there is no problem in it. Okay, then you do one thing. All these matters you just say. Hard landed counsel for the parties. The challenge to the impugn order and the writ petition is against revocation of regularization stroke discontinuation of service of the petitioners from the post held by them. Stop. The assertion made by the respondent in their affidavit of opposition that the passing of impugn order became necessary in view of the fact that none of the petitioners were taken into service by following the provisions of service rule of the district council contained in what is service rule just
Yes. We have given a copy.
earlier it was given.
It was given.
Yes.
Yes.
Oh, Khasi Hills Autonomous.
Yes, yes.
Khasi Hills Autonomous District Council Service Rule 1961. You'll get it here. Stop. The contentions raised on behalf of the petitioner is that none of the employees in the district council has ever been recruited by conducting a regular selection process in due adherence to the provision of the service rules. Stop. Here paragraph. In view of the submissions made by the learned councils to the parties, it becomes necessary to direct the respondent to file an affidavit.
Additional affidavit.
You can time in these things, file an additional affidavit, bring into record as to the availability of each of these availability of sanction post. In relation to which these writ petitions are filed. Stop. The affidavit shall also state as to how many employees are taken into service in the post in question by holding a regular selection in terms of the service rules of 1961. The respondent shall also bring on record as to how many persons are retained in non-sanctioned post. Stop. With the such affidavit shall be filed within a period of
A week.
within a period of 1 week from today. Now, this order will be in all the matters.
In all the matters.
We said post in question means it will be the writ
Understood.
petition things. Now, this will open Pandora box. You see. It will have a huge bearing. So,
Yes.
you are senior counsel, you know what will happen. Because this will, you see, like if you find that there is the rule has not been at all followed, then definitely this court of the view, this non-adherence to rule cannot be a ground for their ouster from service.
We will file. I will satisfy your lordship.
My lord, may allow me to
Because
file
my
a...
lord, one thing is that we cannot continue with the state of affairs. What has been going on?
Now, whether this order can be passed in the new case?
Yes, my lord, let it be included.
No, but then in the new case you are yet to file your affidavit in opposition, then the rejoinder has to come.
That affidavit will be filed during the course of the day. One affidavit on the remainder.
No, but then so long it doesn't come, we'll,
Okay, my lord, we can segregate that only 30,
which matters where affidavit is to be filed?
364.
364.
That is that serial number?
Causeless.
36, I think.
Causeless.
Or that serial number of yours? Chart?
Yes,
In the causeless.
Do you have that in your...
We will get.
Oh, 36, the newly, that
36.
one which you have entered.
Yes, 36.
Okay.
In today's causeless also.
Okay,
it's
so
36.
there you are yet to file your affidavit.
Yes. There we will find during the course of the day.
Okay, just say 64. You are in 364, Mr. Wala. And what is the last case which was moved?
this was 364, my lord. I
Then
can remember.
was it by Mr. Wallang is appearing?
No, moved by me, my lord.
Mr. Wallang is appearing in which matter?
Serial number 34, my lord.
So there already affidavit has come and rejoinder also has come. So that will cover by this. Only that the last item. See, writ petition number 364 of 2025. We just say on prayer made by Mr. Titigi Indo, non-senior counsel, assisted by so and so. 1 week's time is granted for filing affidavit in opposition. Shall we say that anyway? That other one will just say.
He'll cover.
One second, we'll just list accordingly.
My lord, may allow me to file an affidavit to bring on record the RTI which has been furnished to me.
Okay. In all cases,
No, my lord, only in one case.
which case you will file it?
This is...
Whether it will have bearing in all the
20.
cases?
my lord?
It will have bearing in all the cases.
My lord, in my respectful submission, definitely, my lord. Similar situated cases, They have been retained back without any order of the court, without anything.
Whether that is so, then you will bring
Only because RTI was filed only on behalf of.
so you will anyway, RTA can be filed by anyone. It can be brought in into records by anyone. So we'll bring it into which case? Just which was
220 of 2025, my lord.
So that is in serial number which?
4, my lord.
Okay. This is writ petition number 20 of 2025.
WPC number 220 of 2025.
Can't it be filed in the first case?
I can do that
If
also.
you
no
want
problem.
it to be taken into
It'll be
consideration,
easier.
Then I'll file in the first case.
because a
my lord.
lot of inconvenience.
Because, my lord, it becomes easier, my lord, in that case. Because RTI, like your lordship, has, because she is also a
Of
party.
course, that will give a cause to the aggrieved party to challenge it. You can file it in the first one.
My lord, I'll do that,
Just,
my lord.
just in the after the main order which is written in just first one. On the Mr. L. Karim learned counsel that in the petitioner submit that some more relevant factors, more relevant information obtained by the just say some new information. Just say some new information obtained by the petitioner. Come on, relevant for the purpose of this case is required to be brought into record by an additional affidavit. The prayer has and hence prays for permission to file one additional affidavit. Bring on records the additional information. The prayer has not been opposed by the learned senior counsel appearing for the petitioner. Prayer allowed. Petitioner may do the needful within the period aforesaid. That means 1 week. 1 week. What do you say? Okay. List after 1 week.
My lord. Interim time, my lord.
That is required.
It's not required.
There are some cases where district council has not taken any action also. Even so anyway, the interim order passed earlier. Shall continue to the next stage. There may be alteration or use of alteration of words or anything, maybe here and there. Because sometimes if we dictate something in courtroom, we'll type we find that.
Especially when there's so many cases.
So there may be some contestation. Yes.
I'll oblige.
No, these things may have a. If you say we know that you are very fair, Mr. Yingdo, and if you say that that is the situation, then how we can correct when this person, when some people, those who are in service already for 30, 40 years or maybe retired,
That's why, my lord,
will do something to revamp the thing.
that's why, my lord, this committee was formed. When in fact, the committee consists of retired IAS
See,
officers.
the
who have-
formation of committee may be one thing, but then you see, like you may have a better thinking than the entire community. You say, like somebody must have understanding. So that is what is the problem.
But some decision has to be taken, my lord, because this cannot be continued.
No, that is the cause is definitely.
Yes.
It's a genuine cause, and that is a constitutional mandate also that you should do this. But then there will be consequences.
Consequences are bound to be there.
And we just see what happens. Let us. It is not a PIL, so we cannot give it a scope of PIL. Otherwise, we think what to do. Yes, oblige.
37.
Please, Lordship.
My lord, I have seen his calculation, my different calculation. According to him, the delay is 757 days. And my one is, my lord, 809 days. It's a variation of 2-3 days. Well, I would support his calculation, no problem. But my only
Variation of
contention
how many
is,
days you said?
but his calculation is 757 days delay.
And
Whereas-
yours is 890 days.
Yes,
So it
809.
is a variation of a huge, more than 30 days, more than a
Then
month.
My lord, 8,
But then
19, 10
your
days.
calculation apparently is not very right, I think, Mr. I think it is there is some wrong calculation is there.
My lord, therefore, to avoid this, my lord, I will support the calculation made by him. My lord, 757 days. My humble submission is that there is no explanation. Therefore, the application is not sustainable. More than 2 years delay is there. We expect that the applicant should come up with a reasonable
What is the
explanation.
law in relation to that when there is no sufficient explanation of delay?
My lord, that it cannot be
You
continued.
have any decision?
My lord,
You have not come with a decision.
my lord, that I should not trouble to my lord. Lordship is very much aware of that.
No, that
If there is no explanation, my lord,
it cannot be.
Lordship cannot exercise the discretion.
You have to show us even if we find that there is no enough or maybe sufficient explanation. Can you condone the delay by looking at the merit of the case?
Lordship has to consider.
See, there are decisions on that. Perhaps, do not know. This
That
is for
is
the
true, my lord.
councils to find out.
But that is
want
true.
If you want to oppose and if you do not want to oppose, then without going into hassle, we will condone the delay.
But I am opposing. I am opposing. Lordship, while exercising discretion for condonation, Lordship has to look to two facets. One is the nature of the condonation, and second is the nature of the merits.
Give us law, perhaps there is some law.
But Lord,
Holding field.
if that matter come up tomorrow, I will please the judgment. Otherwise, Lordship is very
Yes,
much aware of
what is your contention, Mr. Sangma?
Lordship,
We tried to discourage senior counsel from opposing your thing. He is not inclined. Yes.
of course, Lordship actually have some explanation I have given your Lordship, which I have stated. However, my senior is rejecting since I also have the decision, but I don't have right now. Also, if he's requesting, I also try to place some judgment,
Okay.
which will
So you are also requesting.
requesting in the sense like which will enable the court to go through this and then which will help our case.
Yes, if his condemnation petition is to be contested, then definitely you should come with law.
I also place some judgment now. The calculation part is okay now. Only
Calculation
the
is okay now. It is clear.
only
It's-
regarding
there is-
the explanation part. So
that is what is more important.
I try to assist the court will bring some judgment. I have write it now, but since I have not
Yes.
bring it.
And what kind of explanation is needed to be given?
Yes.
That is what.
I
Whether it's a day-to-day explanation or something, like taking into consideration the overall situation, those are things. It should not be something like that you offer explanation for exempted period.
No,
And for
only
period
only
those which for which there is real delay, there is no exemption. It should not be something like that.
know that.
Okay,
Any
what-
matter come after 1 week. I will also place some judgment. Let him also bring so that we can assist the court in a better
Is that
way.
all right? Okay. So just one prayer. Made for on prayer made by Mr. P.T. Samuel, learned counsel for the petitioner. List this matter after 1 week to enable him to prepare further in the matter. Yes, state is also a party here.
Yes, Your Lordship. 2 and 6, Your Lordship.
You have any say here? You have no say. All right.
Oblige.
Much less Lordship.
38.
His Lordship, in this matter I have filed the
We have received, my lord, the
Affidavit in opposition.
yes.
Okay. Counter affidavit you have filed. So now the matter is ready for hearing?
My lord, you please 2 weeks time to file rejoinder.
Okay. Okay. It is submitted by this counter is on behalf of the respondent number 2, isn't it?
Lordship.
Respondent number 1 is not filing any counter. Not necessarily. Okay. Mr. P.T. Samuel, Learned Counsel is paying for the respondent number 2. Submits that the affidavit in opposition on behalf of the respondent number 2 has already been filed. Stop. Mr.
T. Maranga.
T. Maranga, Learned Counsel appearing for the petitioner, prays for and is granted 2 weeks time for filing rejoinder to the affidavit in opposition of the respondent. List.
Hari Obaj.
Much better Lordship.
39.
Yes.
Please, Your Lordship. Your Lordship, in this matter was first referred to the mediation, and thereafter the matter has been settled by both the parties, my lord. And she have got all the benefits which
Settled,
was
Your Lordship.
entitled.
Okay, it is submitted by MS Sage, Learned Counsel, appearing with the petitioners, that the grievance of the petitioners, grievance by the petitioners was settled before the mediation committee and the petitioners right now has desired to carry on. Has right now is not petitioner, and hence the petitioner is no more interested. Just as and hence has been settled in the mediation committee, and hence the petitioner is no more interested to press this application in view of the submission. This great petition stands closed.
Highly obliged, my lord.
Being infractuous.
Lordship.
Yes.
Highly obliged.
41.
May I please, Your Lordship?
Yes.
Lordship, the affidavit of status report for respondent number 7 has been filed, Lordship.
Yes. Have you filed it?
Yes, Lordship.
And what does it say? It's been served.
Lordship, it has been delivered to the respondent on 2/8/2025, Lordship.
Anyone appearing for respondent number 7? Who is respondent number 7?
Lordship is the second wife.
Second wife.
Lordship, I've just.
How do you know who is first wife and who is second wife?
I'll just ask for the pleadings.
Yes, for the pleadings. This is a pension matter concerning pension benefit. Where is it? Where is this certificate?
Lordship?
Where is the certificate of service?
Lordship is not attached with the thing, it's just shown
No,
the.
this is the tracking details. That will not do. You have to obtain certificate from the
from
postal
the chief,
authority.
chief postal master.
But Lordship, it takes time. Otherwise,
No,
Lordship.
no. It does take time. Those who are doing this, just ask them. It doesn't never takes time, and that is the practice. You have to obtain this thing.
Lordship,
Yes, sir.
it takes time.
If it takes time also, then you have to go by that, because this is the tracking details will not be acceptable. It's not acceptable. All the service affidavits filed here is on the basis of the certificate issued by
Then Lordship, I'll file.
postal authority. Yes, it is submitted by the Learned Counsel for the petitioner that an affidavit showing the effectum of delivery of notice upon the respondent number 7 is filed. Step. However, the perusal of the affidavit shows that the same is not supported by proper certificate of service issued by the concerned authority. Step. The petitioner shall file a fresh affidavit in service respect of number 7, in respect of number 7, after obtaining necessary.
Lordship, in this matter, I'm appearing for 2 to 5,
after
Lordship, for
obtaining
the
necessary.
board, electricity board.
From the concerned authority. List after 2 weeks.
May I please,
Highly
Lordship?
obliged.
Lordship, in this matter, I'm appearing for the electricity board, Lordship. I responded number 2 to 5.
You are appearing for
The electricity board,
electricity board. Respondent number 2 to 5.
Lordship.
Okay, so there was no appearance on behalf of you before that. Was
Before that, no, Lordship. I've just entered appearance.
Okay, none. Okay. Previous none. Before also there was no appearance, isn't it? Okay.
Lordship.
Then
Respondent 1, Your Lordship.
First.
okay. Then before before you write that part of the thing, just say Mr. H. Kharwanlang, Learned Counsel has entered appearance of behalf of the respondent number
225.
225. Their appearance will go in the main thing, the top. You do not have to write it. Then give the list. Then you will file an affidavit.
Lordship, I've just received instructions also that the matter.
Okay, we'll have it after 2 weeks once you take files and 6.
Lordship.
Hello, Lordship.
Respondent number 7 is essential for.
As of right now, she hasn't entered appearance and.
You are for?
The
6 already
Accountant
appeared.
Accountant General.
No, but then 7 is
Private respondent, Lordship.
private respondent. Okay. That's the main contesting party.
Lordship.
Okay.
Possible.
Yes.
Hearing item number 42.
Amit, this is your lordship.
Yes.
Lordship, this matter relate to the CMJ University cases. So, your lordship, now what happened, your lordship? The department had appointed a special counsel to conduct all those cases. So, in that view, the matter, your lordship.
But I've been instructed to appear in these matters, CMJ matters, since we are handling
All the
matters
CMJ
also.
matter.
So I've received instructions to deal
No,
with this matters.
CMG is in now it is not
It's also they
existent.
filed a review and it's
Then you will be appearing. You will be representing.
As a special counsel, your lordship. A special counsel
For the state.
your lordship.
No, but then what about their grievances? And all? Like, is there any authority to look into the grievances?
I'll just work on that also. Just,
The matter may kindly be adjourned, your lordship, on my.
simply adjourn.
Yes.
We will adjourn it then. Yes, if there is somebody, some officers or some is thing for redressal of grievance, then definitely we'll direct you to be there first.
My lord, that we will submit on that issue. Since my learned friend is in the ring for the first time, seeking some time, I have no objection.
So then your appearance, can we record your appearance on behalf of,
I'm entering appearance. I'm just making
on behalf of then?
A special counsel on behalf of the rest
state.
of the state.
Then what about you then?
Lordship, I'm.
May record any one of us today.
No,
Next time I'll be
no, but then if see like, if party is represented already,
Yes.
there is no question of is he recording appearance. Only thing is that, anyway, I'll just say we'll do one thing.
Lordship, one.
You both of you will
Yes,
represent
we
the same
will-
party.
Lordship, yes.
Okay. So even after Mr. Nongbri's entry, you will remain here.
Let me see, your lordship.
We do not know then. Anyway, just for
Lordship.
today, you just say.
For today, only
today.
record double AG's appearance.
Okay. Just you say. No, you just say one prayer made by Mr. N.D. Shulai, Learned AG, assisted by. Yes, appearing with Mr. Nongri, Learned Counsel. You are not a government advocate.
No.
Learned Counsel.
As a special.
Acha, Learned Special Counsel.
Lordship.
Learned Special Counsel. The matter stands urgent. List after 2 weeks.
2 weeks. Oblige, your lordship.
Try to sort out the things. You see, like this will be difficult. I do
Lordship,
not
in fact,
know
there is an adjudicator, your lordship.
whether you can pass any order or not. And if some order is passed and if it cannot be executed, then at least writ court will not issue any futile writ. That is the main thing. Just see, there should be some authority to take care of their grievances.
Administrators there.
Administrator is there.
for compensation.
For compensation, for violation of public
All
law.
the
Is it
same.
very
This is
big amount or
different
is it
stream.
big
Different
amount or small amount?
Big amount, your lordship. Whether that would lie also in the writ.
43 of the same.
Oblige. 42, 43, your lordship.
Or 42, 43 also will be same
Same issue, your lordship.
42, 43 also.
Oblige, your lordship.
Mr. Sangreshu is there in 42, 43 as
In
petitioner.
41, my colleague is in the next
Then
item.
Mr. Abraham in
43 and my learned senior is in 42.
42.
you are in 42. You are in 43 and then another one.
Only those
These
Two matters.
These two matters.
Just name the name.
45.
Oblige, your lordship.
Lordship, in this matter, I am seeking for some accommodation on behalf of Mr. R. Datta's Lordship. legal aid counsel. She's on leave, Your Lordship.
That is that issue. Scheduled caste certificate. OBC certificate. Yes.
Matter was already heard. I think it took time for some further preparation.
No, then she was supposed to produce something. She's a legal aid counsel here.
Yes.
Okay, just one prayer made on behalf of MSR that LSE appearing on behalf of the petitioner. When?
2 weeks.
List. Then just say, non objected to by the learned counsel appearing with the respondents. List after 2 weeks.
After 2 weeks.
That is what.
46.
So I have similar prayer. And
Yes.
Your Lordship, this is an application to quash and set aside the FIR dated 16/6/2017, GR case number 1112/2019, order dated 19/3/2025, passed by the Judicial Magistrate First Class Action Law. Your Lordship, as per the
What is the order about? The order of the, what is the order of the judicial magistrate?
rejecting the application for praying for discharge.
So that order is not revisable. Yes, order of rejection of order of discharge, is it revisable or not? Dr. Mojika?
My lord.
Order of rejection of discharge application, whether revisable under criminal law.
Your Lordship, our prayer is to quash and set aside the
That is all right, but then you are challenging that order of rejection also, isn't it? Now it's a order passed by judicial magistrate.
Yes,
Now if any challenge is to be made, do you directly come to High Court or you go to the Sessions Court first? If your contention is that this revision is, the order passed is not revisable, then maybe. Otherwise, you see, like 482 is a kind of discretionary relief, isn't it? It's not a matter of right. So how do you tackle with this?
It's all about magistrate.
You see, an order in criminal law probably, if no appeal is prescribed, then revision would lie. Is it correct, Dr. Mojika? So far as the rejection of order of discharge, no appeal lies under the court. Not an appealable order. So naturally a revision would lie.
And this is not an interlocutory order. It closes the matter. I didn't examine it from that angle.
Mr. Shulai may be in a better position to explain us.
CBI is the main party of it.
So you do not want to open your mouth.
So, Lordship, please don't put a burden on me. Allah, Lordship, in fact, Your Lordship will have to see whether the right of the parties
the question of law,
determined or not, Your Lordship.
when a question of law comes, is it not the duty of the senior advocates to assist the
I'm
court?
sorry, Your Lordship. Lordship, we'll have to see whether the right of the part has been determined or not.
The order of rejection, whether it's interlocutory order or not.
It should not be. It's
It will not be.
amount to be intermediate or a final order, because it affects the right of the petitioner here in the Lordship. So in that view of the matter, it is revisable.
Yes, madam, can you give us some law on that?
Your Lordship, on the next day, Your Lordship, I will bring my authority to support this.
Yes, please, just conduct some research on this. The court also will get enlightened if you do some research.
But Your Lordship, we meet three prayer, Your Lordship. One is to quash the FIR and the proceedings.
See, if your the end result is same, if your prayer for discharge is accepted, then you are exonerated. The quashing of FIR also have the same effect.
Then another aspect of the matter also, Your Lordship, it's pending. There is no interim orders restraining the proceeding before the learned judicial magistrate, whether charge have been framed or not. The person
Your
is
Lordship,
better
I will bring to the knowledge of this court that charges are framed and the sections are under the IPC, Your Lordship, without the Prevention of Corruption Act.
But then what happens if this offence under IPC is investigated by CBI under the Delhi Special Police Establishment Act? So whether jurisdiction will not lie with the special judge? And then even if we find that the jurisdiction doesn't lie with special judge, can it be a ground for quashing? Can't we transfer the matter for taking up by an appropriate court?
But Your Lordship, an order has been passed in Your Lordship by this Honourable High Court in similar case, Your Lordship, in the case of Yupatha, Your Lordship.
Yes, by
Yes, Your Lordship.
By a coordinate bench.
Yes, yes.
Now the matter was challenged before Apex Court. Apex Court declined to interfere, but then kept the question of law open. Now that is why so many question of law is coming to you. Because the question of law is open. So now you have to satisfy this court on law.
Yes, sir.
You have to tell us two things. First of all, whether this order rejecting prayer of discharge is revisable or not. This is the first thing you have to answer. Second thing is that whether investigation conducted by the CBI under the Delhi Special Police Act involving offence under IPC, the special judge will have jurisdiction on it. Now the appointment of special judge is whether for the purpose of dealing with these offence involving Prevention of Corruption Act, or for the purpose of, you see, like doing trial where CBI investigate the matter. Now that is what. The rightly or wrongly, see here the investigation was conducted. Originally FIR was lodged under Prevention of Corruption Act also, isn't it?
Yes, Lordship.
The matter was investigated in those premises. Then investigation completed, charge sheet was filed. And there was I think no allegation against you so far as the PC Act is concerned. Some other officials were involved, but then those who are, I think, given clean sheet. Only one person has been retained as accused apart from you,
Yes.
who is not a government employee, but then an outsourced person, isn't it?
Yes, Lordship.
Now he is there. Now another question comes: if an outsourced person performs duty on being appointed by the state, whether he discharges public duty and whether he can be reckoned as government employee so far as the
Your Lordship,
criminal allegation is concerned.
regarding the Lordship, I have one authority with me, Your Lordship.
What does he say? He will be a private individual. He will not be a government. Okay. So anyway, but then that also one thing you have to address with us along with two other things. These are the issues which are coming to the mind of the court at this moment. We do not know whether any other issue will crop up or not. (482), if you wanted quashing of the thing, then why you went to the court and filed an application for discharge? Now you have failed in your discharge application, you come for quashing without availing the remedy of revision. Yes. Tell us what.
But Your Lordship, this instant petition, Lordship, is for questioning the power and jurisdiction of the CBI.
So that is what we need something. That is what I told you. So CBI definitely, that is a point you are raising needs adjudication. But then what we would like to know, you are challenging the jurisdiction of special judge, isn't it? Now, are you contending that CBI does not have the power to investigate matter under IPC?
Yes, yes.
But then here, you see, as we have already told you, here initial launch of investigation was under Prevention of Corruption Act also, isn't it? So,
But,
yes, sir.
but it has to be a connection, and there must be a relation with IPC or with Prevention of Corruption Act.
Now, whether there is a connection or it has a relation or not, can we decide in 482? Because admittedly, you see, the launch of investigation was because of, you see, like suspected involvement of some government employees, isn't it, Dr. Mojiga? Yes. And then the investigation proceeded in that premise, those premises. Later on, maybe those charges were dropped. Those charges under Prevention of Corruption Act. Now, whether that will have the effect of, negating the entire investigation.
Your Lordship, in the case of P. Pathao, Your Lordship, the application is under Section 482, Your Lordship, for quashing of the FIR and the entire proceedings.
Even quashing of FIR also, you are raising these grounds, isn't it? These are of your grounds of thing. Investigation by CBI. CBI cannot investigate the matter under India Penal Code. Is it your submission?
Yes, yes.
So, that is what we want, I think. If you have any ready-made decision to support your things, it's all right. You can proceed with that. But then you have to satisfy this code. Yeah.
Your Lordship, I pray that I may be allowed to bring some authority, Your Lordship. On
Please, you do it. That is. Yes, Dr. Mojiga, we'll be needing some.
On this, there are several. I placed those decisions in T. Pathao's matter.
Of course, the primary, it is her responsibility, they will bring it. Let us see what she asserts, depending on that, Mr. Shulai also will be there. Because 482 other is a discretionary power, cannot be a matter of right. It can be invoked in a case where their provision contains the code. Cannot be availed. For
if revision before session court is clearly maintainable, then in that case, they should avail that instead of coming to court.
That will be this will be a discretion of the court whether to entertain this application or to relegate them to there. Because the fact remains, immediately they approach the trial court for discharge.
Yes.
And the cause of action for filing this is also the rejection of.
Yes.
Have we just say on payment by Miss ADCM, Learned Counsel appear for the petitioner? The matter stands adjourned for 2 weeks. List up. Learned stands adjourned for 2 weeks. Don't have to say anything. Yes.
Apply, Your Lord.
How many matters are there? Which matter is there? Just call. We have to rise for division bench. Yes. Call.
48.
Yes. What is that?
This is a criminal petition.
Oh, quashing.
Yes, Your Lordship.
You have to wait. This court will have to rise for DV. And there are 2 DVs, so we do not know what will happen.
Wait.
We'll wait for single banks to come.
Your Lordship, I beg to mention urgent listing. Yesterday I mentioned, but
We are not entertaining. This reflects on the responsibility of the council. You will not allow. There is no question of allowing it. Once you have taken permission and you fail to file it, we'll allow. Now wait for your turn. We will not pass any order. We will not. Yes.
Lordship, join request, Lordship. Day after tomorrow, Lordship.
See, day after it will go after a week. See, day after tomorrow means that has to be disturbance for things. Then after a week.
After a week.
Just say then this one. What was the item number that you given?
48, Lordship.
Just one joint prayer made by the parties. Just after a week.
Obliged, Lordship.
This will be. There is a compromise, isn't it?
Compromise, yes.
It's a
I have
covered
obtained
matter.
the instruction.
Okay, just
Obliged.
we can dispose it on then.
Yes, Lordship. Obliged.